Hi, I'm Brian Heidelberger, a partner with the law firm of Winston & Strawn in Chicago, and here today with another mini advertising law lesson. Today's law lesson, what you need to know about Canadian advertising law. But first, I've received so much hate on the clothing that I wear. I have gone straight to a white sweater, no muss, no fuss. I hope that's good enough for all you fashion critics out there. So, what are we talking about today? Canadian advertising law. Well, as much as it might seem like I like to babble on about things I know very little about, even with my crack production staff, I am unwilling to fake it. So today I've got a special treat for you, Canadian advertising law expert Brenda Pritchard from Gowlings in Canada, and she's going to tell us about what we need to know. So Brenda, tell us, I know there's been a lot of talk in the United States about testimonials and endorsements and the recent FAQs coming out from the FTC and .com disclosures. What is Canada's position on that?
Canada's answer to the FTC guides and Q&A was issued in June 2015 by the Competition Bureau in the form of Deceptive Marketing Practices Digest. While the Bureau did not really give explicit direction like the FTC in terms of what types of disclaimers must be used, where they must be, it was clear that in the terms of astroturfing, they consider any failure to disclose a material connection to be materially misleading. With respect to disclaimers, they have two basic principles. The first is that any disclaimer can, in fact, give more information or, in fact, even clarify an ambiguity on a claim. The second principle is that a disclaimer should never contradict, negate, or curtail any claim. Without admitting the effectiveness of the one-click rule in various platforms, the Competition Bureau said that you have to make sure that any disclaimers work in all formats and all platforms and well shared.
And what about the anti-spam law? I know that there was a recent law enacted. What actions have there been in that regard?
We had first, second, and third blood on Canada's anti-spam legislation this year. Starting in March, the first case resulted in a $1.1 million fine against CompuFinder, which had Castle complaint alleging it promoted its training materials without proper consent and unsubscribe mechanisms that did not work. The second case was against Plenty of Fish, who sent commercial electronic messages to registered users with an unsubscribe that was not clearly and prominently marked and could not be readily performed. That resulted in a $48,000 fine. The final case just came out June 26th against Porter Airlines for what we would consider to be technical violations, resulting in a $150,000 fine. So, given the strict enforcement and high fines that are resulting from breach of Castle, you may want to look at your policies and procedures to make sure that you do not have any technical violations.
Brenda, we all have heard a lot about French language requirements for Quebec. Has there been any recent enforcement in that area?
As you may be aware, signage in Quebec must be in French unless it is a recognized trademark. So a lot of English trademarks on signages were appearing in the province of Quebec, and there was a case. The retailers won at the Court of Appeal, and it was determined that they could leave their recognized trademark alone in English on the sign. The Quebec government responded by saying they're going to amend the Charter of the French language to require the retailers to add additional French language in addition to their trademark. So if you're a retailer that's carrying on business in Quebec, make sure that you have a recognized trademark so that you can put it on your signage. If you're doing business with people in Quebec but don't actually have a place of business or advertise to those people in the province, then you may be outside the jurisdiction of the Charter of the French language.
Now, one of the hottest issues in advertising law here in the United States is privacy. What has Canada been doing about privacy law?
The Digital Privacy Act was declared into force June 18th, amending Canada's privacy legislation. It included, among other things, breach reporting requirements, business exemptions for data transfers, new enforcement powers for the Commissioner. So now that Canada has detailed breach reporting requirements, you may want to consider your policies and procedures to make sure you're ready.
Brenda, thanks so much for your advertising law expertise here. For those of you who have more questions, Don't hesitate to reach out to Brenda Pritchard at Gowlings in Toronto, and you can always find more mini law lessons at youtube.com/Brian Heidelberger, or follow me on Twitter at Brian Heidelberger. And until next time, let's be careful out there.